And hello, we are live. And
Hello.
I'm gonna hand this to Tiffany since it's actually her channel. I'm just,
Hello. Welcome back to
Hello.
Wiki Wise. Today we have Spanny from Fight or Cries, who's my other twin. She's the good one. I'm the evil one, so nobody gets it twisted. And then we have Amber and Mr. Downing on today. And Mr. Downing has a lot to share with us. We are going to do this as quick as possible because we only have an hour. So with that, Spanny, do you have anything to say before we hand it to Amber and Mr. Downing?
nope. Welcome both of you, and let's do this.
All right. Take it away, Mr. Downing and Amber.
Hey, everybody. Can you hear us?
Yes.
Awesome. Awesome. So we're ready to get going, right? We're live. Awesome.
Yes, we are.
Okay. So we've got a lot of problems with the justice system, and we got to look at the historical underpinnings of the issues. So when we established our country, we created what was known as an egalitarianism form of government, which is the belief that all men are equal. But in order for all men to equal, government and laws must first treat them equal. So every single person is entitled to fair and equal governing in the same way that they're entitled to the fair and equal protection of laws. We all know that you have equal protection of laws. But if the government is responsible for administering and enforcing those laws, then an attribute of fair and equal application of laws is fair and equal governing. So when government chooses to take a side against you, it's not administering those laws fairly and equally, and as a result, we have a complete breakdown of the system. So the foundation of our system we call just is not based upon just principles, because our founders, they failed us from the very beginning. And what they did was they refused to give up what they called their property and actually make all men equal. And as a result, we've created not a just system because it's not built upon just principles, but instead a system that has the ability to perpetually discriminate. We've got to start this system over. We've got to create a system that actually has just principles built into the foundation and not the institution of slavery. And so, what we're doing across the country is we are we're doing a public awareness campaign. We're bringing this knowledge and this information to the public so that they can understand the true nature and reality of the system, so that we can actually achieve what the desired outcome is, and that is um, a correction of the system built upon true just principles, as opposed to um, the foundation being the institution of slavery. So,
Well, can I ask you something real quick? I don't mean to cut you off.
yeah.
So in the Declaration of Independence, I believe it might be the Bill of Rights. I have to look it up. But anyway, does it or does it not say that we, the people, have the right to abolish a corrupt government and start over?
That's the Declaration of Independence, and it's so what happens there is that's built upon a number of different theologies. So John Locke is the father of our current system, the theology of our system. Jacques Rousseau was one of the philosophers that designed it as well. Our founders and forefathers, they knew that when you have a system that reduces the people into a state of enslavement and removes property and life and everything else, that we have the right to be able to breach our obligation of obedience to the government until they return to the established rule of law. And that's the philosophy behind all of this, is that if our government created a contract, which is what the Constitution is, it's a contract between the people and the government on how they are to govern us. If they choose to breach their obligation that are codified within the Constitution, breach the obligations that they have, then we then have the right to be able to breach our obedience to the contract and establish and restore our original liberties. And what we're saying is we don't want to go back to a state of original man, because in the state of man, all of the rights that we have are actually not good rights. We have the right to kill in the natural state of man. We have the right to steal in the natural state of man. We don't really want those things, and that was the purpose in establishing the Constitution, the social compact, was to give up certain rights that are negative in order to receive in return rights that are protected, and government's purpose was instituted to preserve and protect those rights not given up in the social compact. So we all have the right to life. We all have the right to liberty. We all have the right to an environment of happiness. We have that because we've given up our right to kill another human being in order to preserve our right to live. We've given up our right to be able to imprison another human being because we want to have liberty. We've given up those other rights, such as steal and so on, so that we can have those rights ourselves. So Thomas Jefferson says that we gain civil rights as a result of choosing to defend and protect the rights of others. So we all have an obligation to protect and defend the rights of others, because if we don't, then we ourselves don't have it, right? So we've got to learn that we've got to defend and protect against all rights in all circumstances, in all instances, because if we do not, then we don't have those rights that we claim to have, and that would be a fundamental breakdown. So we need to make sure that when we choose to take away the liberty of another human being, one of our brothers and sisters, that we are losing that right. We're giving that up to the government to be able to take ours ourselves. And one paragraph within the oral arguments that we have to the Supreme Court is that we who are free can only boast in the freedoms that are real and not an illusion. We're each only as free as the freedoms that are extended to all and not simply some. Any time a freedom is demanded or stolen from one through justification or ignorance, that freedom and right is lost to all and not simply a target of scorn and punishment. Any freedom which can be removed from one can be removed from all is no longer freedom, but simply an illusion of freedom. Evil shows no favoritism. When evil is given birth, it becomes a thief, and once a thief, we all must bear the consequences of its evil thievery. So when you look at a law is nothing more than the establishment of an obligation. Right? That's all that a law is, and it's very simply put. We need to look at it from that perspective. A law creates an obligation. So I have an obligation to not kill someone, or I have an obligation to not violate a woman. I have an obligation to not steal from someone or assault someone. If I breach my obligation and I assault you, now your right to not be assaulted has been violated. Therefore, your rights derive from another's duty to act. Right? Your rights do not exist until someone else breaches their duty. And that's so important when you look at the Constitution in particular, because the Constitution establishes the obligations of government. That is all that the Constitution does. It creates the obligations of government. Therefore, when you want to pursue a civil rights case or establish a right and say that it's been compromised, the very first thing that you must do is you must show that someone else had a duty to act. They breached that duty, and now that gives rise to liability. And so that's why most civil rights cases fail in procedural default, is because they fail to understand where their rights come from. Your rights derive from another's duty to act. So until you establish that someone else has a duty to act, you have no liability, you have no rights that have been violated. And so that's what we're trying to do across the country here in bringing this awareness to the people, is that their rights have been detrimentally compromised by our own government and agents of our government. They are not following the procedures and processes that are agreed upon by in the form of code of conduct that's established by the majority. And when they do that, then that means that their actions are outside of the law. And if your actions are outside of the law, then everything that you're doing is unlawful because it derives from an unlawful act. So this whole issue of criminality. Yeah.
So let's say we're just going to use CPS because I hate CPS and they hate me.
Yeah.
Okay. CPS shows up at the door, right? They don't have a court order. They're told to leave. They fraudulently go get a removal order from a judge. Okay. Now they go to the police department, and the police now, only if the child is outside of private property, can snatch the child. This happens. What do I do?
Yep.
Because my rights have been violated. My child rights have been violated. What do you do?
Yep. So let's say that this is the order right here. Here, let me find out where we're at. So this is the order that CPS prepared to hand to a judge. This order says, "Judge, please take away the rights of this parent. Let's take this child." Okay. So under federal law, United States Code, you have USC subsection 242, which is deprivation of rights under color of law. We need to understand the history of that law. The history is that was created in order to ensure that from henceforth, following the Civil Rights Act, that those rights that are enumerated within the Constitution of the United States, particularly the Bill of Rights, are from henceforth guaranteed to all persons that reside within the jurisdiction of the United States. Now, what happens is that in 1984, the United States Supreme Court came out in a case called Roberts versus United States, and declared that that you have a right to intimate association, which means that you have the right to have an intimate familial relationship with your children. They have the right to have an intimate familial relationship with you, and that is to be done without governmental interference, right? So you have the right to be able to raise your children in the way that you see fit. That is a fundamental constitutional right. Now, there's different types of constitutional rights. The highest is what's known as the civil liberties. Those are the fundamental constitutional rights. Those are the ones that are actually enumerated within, secured by the Constitution of the United States, particularly the Bill of Rights, the first 10 amendments. So when the Supreme Court comes out and declares that there is an intimate familial relationship that exists, a fundamental constitutional right for intimate association that's guaranteed and been found to exist within the First Amendment, right, and the freedom of conscience, the freedom of religion, if they declared that, then that is the highest form of constitutional right that there is. The lowest form would be a civil right. A civil right is what society comes together and says that we want to give these rights and guarantee these rights to all, and therefore we're going to place it into the Constitution, thus granting and guaranteeing these rights to everyone. A fundamental constitutional right is in the Bill of Rights, the first 10 amendments. A civil right, for instance, is the right to vote. That's not within the Bill of Rights, but it was established to be something we want to guarantee for all persons. Therefore, it becomes a civil right. Now, when you deal with a civil liberty or a fundamental constitutional right, there's only one way that it can be taken away, one way. And that is through what's known as strict scrutiny. Strict scrutiny requires what's known as the compelling state interest test. So there's 4 levels of judicial tests that exist. The highest and most stringent is known as the compelling state interest test, is strict scrutiny. And what has to happen in strict scrutiny is that the state has to go out and they have to prove that there's nothing else that can be done but to take away this fundamental constitutional right from this individual. And it's a very, very high measure to reach. In fact, 90% of all cases that have strict scrutiny applied to it wind up being defeated in judicial review because it's determined that the state has exceeded the power authority statutorily conferred upon it by the Constitution. So the highest judicial test is strict scrutiny, compelling state interest test. The lowest judicial test out of the 4 is what's known as discretionary test, which means that the judge has the discretion to take this away. So when a judge accepts a document and says, I can use my discretion to take away this right, failing to understand that that is a fundamental constitutional right, he is applying the incorrect judicial test to make that determination. He doesn't have the right to do it by discretion. He must pass a higher level test, which is known as strict scrutiny. And so when you were to open up, if you were to open up the Circuit Court Handbook, the United States Circuit Court Handbook, which is the Court of Appeals, and you were to look up the abuse of discretion, it applies a 2-part test to determine abuse of discretion. The first part is, did the judge apply the incorrect test? Well, I just showed you that he did. He applied the incorrect test. He used his discretion to take away something that requires strict scrutiny in the compelling state interest test. So on the first measure, yes, he did abuse his discretion. The second part is any erroneous view of the law is an automatic abuse of discretion. Now, let me tell you what an erroneous view of the law is. An erroneous view of the law is the belief in the judge's thinking that a state statute that allows him to deprive a person of a fundamental constitutional right is in legal contemplation superior to the fundamental constitutional rights that are enumerated within the Constitution of the United States. That would be an erroneous view of the law. He would be looking at it from the lowest form of law to determine whether or not he could take away the highest form of law, and that would be an obvious erroneous view of the law. Therefore, an automatic abuse of discretion has occurred. Now, when you deal with abuse of discretion, a couple of crimes occur as a result of abuse of discretion. First off, extortion is an automatic. Every single time a person abuses discretionary authority with which he's invested in law, he has committed the crime of extortion. Extortion is simply compelling a result through illegal means. That's what it is. It's still a crime. He's also committed the crime of perjury because he's failed to adhere to the obligations that he has statutorily had imposed upon him as a result of the oath of office that he took to enter into his office. So under Article 6, it says the judges in every state shall be bound thereby anything in the Constitution or laws in state contrary notwithstanding. Those judges are bound to adherence to those obligations that are created and codified within the Constitution of the United States. And therefore,
so wait a minute.
Yeah.
What if you have a judge and you bring this to their attention, right?
Yeah.
You're bound by the Constitution and this has happened. You hear from a judge that tells you the Constitution does not apply in my courtroom, or you say the United States versus whatever, right? The Supreme Court rulings, the Supreme Court does not rule my courtroom. What do you do?
So herein lies the problem. If the lowest court in the nation has the right to deprive you of rights that the highest court must protect, then the only option that we have at this point in time is to go to the highest court and demand that they assert their supremacy. Because if the lowest court can take away rights that the highest court cannot, whose court is more powerful? The lowest court.
Courts.
Right. And so we have a complete flip in our judicial theology today. And we must get the United States of America and the Supreme Court of the United States to understand that if they want to continue to have a job, if they want to continue to say that they are what they are, then they must assert their supremacy, and they must get the lower courts to adhere to the rules and obligations that they have. And if they don't, then God help us all. That's all I have to say. God help us all.
So now the same scenario with CPS and the judge and all that. Now there's a crime, right? Because now the prosecutor says, oh, this says the child has a broken arm, whatever the case may be, right? Alleged and a belief that this child is being abused. Now you're charged with the crime. Like, I live in Virginia. So the state of Virginia is now charging Tiffany Wise with the crime. What do you do?
So the criminal element is something that's near and dear to my heart, all right? Because across America today, there are more than 600,000 people that are currently imprisoned on direct facial constitutional violations. Direct facial, meaning that their judgment violated and breached a direct facial constitutional obligation that exists, which means that their judgments that are in place are not valid. They're void because they're tainted by the illegality of the way in which they are obtained. If you breach a constitutional obligation in the pursuance of the adjudication of a crime, then that makes that adjudication unconstitutional because it derives from an unconstitutional act, period. And so, one of the things that people need to understand is that I'm not fighting for anyone's innocence. I'm not saying that they're innocent. I don't know, and I don't care. That's not my problem. That was the state's problems, but the state failed to do what they were constitutionally obligated to do.
We froze.
Because to the process. And if you don't follow that process, there cannot be guilt. So this is a jurisdictional issue, all right. And I hate to murky up the waters, but on the criminal side is very simple. Article 3, Section 2 of the United States Constitution says, in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction. Now, don't just believe me. I need you guys to go out and I need you to look at this yourself because this is the law. And when you look at it yourself and you see that the things that I'm saying is true and accurate, then you can cut through all the bullshit that you hear from judges. You can cut through all the bullshit that you hear from attorneys and prosecutors. And you can see that the supreme law of the land says that this is true. So in all cases in which a state shall be party, the Supreme Court has original jurisdiction. So in order for a court to render legally binding decision, in order for it to speak the law, right, it must have two things. It must have subject matter jurisdiction, which is the right to oversee the type of case that's brought before it. So for instance, in the case of a death, you would not bring that to a small claims court because they would not have subject matter jurisdiction to oversee the disposition of the deceased assets. You would bring that to a probate court. That would be the court that would have subject matter jurisdiction. The second thing that they must have is personal jurisdiction, which is the right to oversee the parties involved in the dispute. If the Constitution states in Article 3, Section 2, that there's two instances in which the Supreme Court of the United States has original jurisdiction, meaning that it is the court to act originally before any other court, no other court has the right to act before that court, then that means that exclusive personal jurisdiction is constitutionally codified as an obligation to the United States Supreme Court anytime, one, a foreign dignitary is named a party, or two, anytime that a state is named a party. If either one of those two instances exist, then the United States Supreme Court is the only court that has the jurisdiction, personal jurisdiction, to oversee the disposition of that dispute and the parties involved in the dispute. So CPS too. And that would, yeah. So we'll hit CPS on this because CPS is an agent of the state. It works for the executive branch. It is enforcing the laws, right? It is an agent of the state. So if you want to understand the provisions of the United States Constitution, typically we go to the founders and we determine, what is it that they were thinking, right? James Madison is considered the father of our Constitution, okay? James Madison wrote the Federalist Number 10. James Madison said in the Federalist Number 10, he said, no man is allowed to be judged in his own cause because his interest would no doubt bias his judgment and not improbably corrupt his integrity. With equal, nay, with greater reason, a body of men are unfit to be both judge and party at the same time.
Mm-hmm.
So when CPS, being a body of men that make up the state, brings an accusation against you, that state cannot be presumed to be neutral and unbiased in the judging of its own dispute. And as a result, that judge has an obligation constitutionally codified to recuse himself, and failure to do so means that he is acting without jurisdiction. And according to Title 28, subsection 455, anytime that a judge acts without jurisdiction, willfully or negligently, he is warring against the Constitution and committing the crime of treason, because he's breaching his statutory obligations codified within the Constitution and imposed upon him by his oath of office when he entered into it. He promised an outcome, and that outcome was that he will do what the Constitution says. Failure to do so means he's acting without jurisdiction. And according to Civil Rule 60B4, 60B4, everybody, go down to 60B4, it deals with the nullification of judgments, and it says that a judgment is either valid or void. It's valid in all instances, except for when the court rendering the decision lacks either subject matter jurisdiction or personal jurisdiction. If it lacks either one of those two things, that is a void judgment. And a void judgment will always and forever be void. It can never be valid because the court cannot obtain jurisdiction when it lacks jurisdiction. So we've got a whole lot of void judgments that exist out there, a whole lot of them. Now remember, CPS works for the enforcement branch of government, the executive branch, right? And as a result, they are operating under the authority of the prosecuting attorney within the county. That's why you oftentimes see a prosecuting attorney that will be on the case, right? So CPS is part of the executive branch. So when a governor says, well, this is out of my hands, I can't do anything, that's bullshit. That is a direct report to you. That is a direct report to the governor, and the governor has direct responsibility and accountability to what is happening to these children across the nation. So when the governor says that he does, it's full of shit. Not true.
And I tell people, see, I'm not a constitutionalist, but my shit, Spanny knows. I am the Constitution girl, okay? I make them do their jobs because I will hold that shit up in front of their face.
She has a book to prove it.
Yeah, not this one, you're not. I threatened the judge. She's like, you will cooperate, you will. No. You will not take my free will. You got the wrong one. Because I will leave your courtroom and I will call a civil rights attorney. You will not do that to this one.
Yeah.
Huh.
So there's a couple more nails that we could put in the coffin here.
Go ahead.
One particular nail in the coffin is if you read the duties and responsibilities of the prosecuting attorney written by the Bar Association, if you go down to item 4, subsection A, what it says is the prosecuting attorney shall prosecute all cases, criminal and civil, in which the state has become a party. Let me say that one more time. The prosecuting attorney shall prosecute all cases, criminal and civil, in which the state has become a party. When Article 3, Section 2 says, in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction, how is it that that prosecuting attorney can claim that he doesn't work for the state or that the state hasn't become a party? Because if he's on the case, the state has clearly become a party according to their duties and responsibilities.
Well,
so that judge,
I tell people to read because every state has a bench book. Comes out once a year, right? Like ours is the Virginia bench book. It's 666 pages. I tell everybody, read it. Read the bench book.
Yeah. So
you're right. So the prosecuting attorney, go ahead.
Well, I mean, that's it. So, when you walk into a courtroom, it doesn't matter if it's a civil matter. It doesn't matter if it's a criminal matter. You walk in that courtroom, the very first question that needs to be asked is, does the court have jurisdiction? If it does not have jurisdiction, then it cannot act. And any action or any orders created by that court is fully void without force or effect because the court has exceeded the statutory limits that's been imposed upon it by the Constitution. If the Constitution is declared that the Supreme Court has original jurisdiction. No other court in the country has jurisdiction, and as a result, every single decision, every action taken by that judge is fully without force or effect and is void under Civil Rule 60.
So what is your advice to parents that are subjected to this in a
Correct.
manner which they feel like their hands are tied and they make these orders and they walk out and they don't really know where to go? Or you have indigent attorneys that are for people that can't afford attorneys.
Or
But
there's
aren't
the
those
corrupt
actually
judges.
a part of the state too, because the state is paying them to provide services for the families. So wouldn't that be a conflict as well?
Yes. So
It is conflict, right? Now you're a retired attorney. Is that what I understand? No. Okay. So
He is a
if I-
civil rights advocate.
okay, that's fine.
Mhm.
Right or wrong, the first
so my-
client of a lawyer is the state. Right or wrong?
Correct. They belong to the state.
Thank
Yes.
you.
So they're barred to the states, and what's occurring is what's known as geographical discriminations. So geographical discriminations have been highly problematic for our nation from the very beginning. When we were originally a confederacy, back in 1776, our original foundation of government was a confederacy, and we remained a confederacy until the Constitution was adopted on September 17th, 1787. We remained a confederacy. At that point in time, we were supposed to become a federal republic. Well, a confederacy it's defined as two or more sovereign states with a loose decentralized governing structure. So the states remain sovereign and they have power to be able to act autonomously however the way they want, and then they have a loose decentralized governing structure. That would be an example of the European Union, right? That is not a union, because a union is two or more non-sovereign states with a central representative government. So what happens in our representative government is that we were supposed to have representatives from each of the regional governments go to a central government, and they were supposed to create the laws, and then those laws would be federated out to each one of the regional governments for application administration. That way all men are treated equally, no matter where they choose to reside within the jurisdiction of the United States. States were not supposed to have their own laws. That's a confederacy. That's not a union. A union, in a union, you give up certain rights and privileges in order to join the union and be subjected to a higher law of which your government is subjected to. So when we talk about the sovereignty of the states, that's a lie. It's a lie that's been proliferated by the Supreme Court for far too long. But
About immunity too. You might want to talk about that.
well, I mean, I think immunity is going to be something that we'll want to do in a different discussion. But the history of immunity is very interesting, because in 1793, the United States Supreme Court had a case called Chisholm versus Georgia. It was the very first case that the Supreme Court heard, and it was an issue of immunity, and it was dealing with this Article 3 provision that I'm talking about right now, where states can be a party in the cause, they can sue or be sued, and Chisholm successfully litigated it. But what happened was, over time, the government has taken away that Article 3. They've changed it through judicial fiat. And they did that particularly in 1890 in a case called Hans versus Louisiana. So what happened was that in 1793, the Supreme Court comes out and says that the states are not sovereign, that they gave up their sovereignty in order to join the Union and subject themselves to the United States Constitution, the supremacy of it. And as a result, they weren't sovereign. And so the states got upset, and they brought forward the 11th Amendment, and right or wrong, we adopted and ratified the 11th Amendment. But what the 11th Amendment says, it says that a citizen in one state can't sue a different state. That's all it says. It doesn't say anything at all about suing your own state, right? And so then from 1795, when we adopted the 11th Amendment, all the way up until 1890, there were major cases such as Cohen versus Georgia and McCulloch versus Maryland and Martin versus Hunter's lessee, where each one of them said that states are not sovereign. I mean, they say it right within the document itself. States are not sovereign. And then in 1890, we had the Waite Court. Now, Waite is well known to be a slave sympathizer. I mean, he misread the law on numerous occasions. He did it to proliferate the industry. He put into place numerous rulings that have been undermining the Constitution, undermining the Union, in order to perpetuate the industry of slavery. And that's kind of where we're at today, is that the ruling in Hans versus Louisiana, which made states sovereign, it wasn't grounded in the Constitution at all, right? And they even stated that. If you go and read the Hans versus Louisiana ruling, they say, we don't read the Constitution literally, we read it figuratively, and we believe that the intent was this. And what they did was they sidestepped the discussion that was on the floor of Congress on both the Senate and the House, because Senator Howard and Congressman Bingham brought the 14th Amendment forward. And what they did was they actually said that, that there's certain rights that are protected under Article 4, which are described within the Corrivel versus Washington case not Washington, Corrivel versus Fieldman, I believe. But it was Justice Washington, George Washington's grandson, that wrote the opinion. And he identified very specific rights or privileges that are identified within Article 4 that are fundamental and found to be exist. But then they went through and they read every single one of those enumerated rights within the first 10 amendments, the Bill of Rights, each individually. And so there's no denying that the intended purpose of the 14th Amendment was to ensure that the states were bound accountable and gave those rights to persons within the United States. But yet Waite decided to sidestep that and go around it and say, once again, that those rights that are enumerated there are not a restriction against the state governments. They're only a restriction against the federal governments, which is a completely absurd statement. But that is still staying in Supreme Court precedent today. That's the reason why numerous states don't provide those rights that are contained within the Bill of Rights to their people, such as the state of Alabama. You don't have the right to peaceably assemble, petition your government for redress grievances because the state doesn't give it in their constitution. That's the reason why there's 13 states that don't conduct a grand jury at all, despite the fact that it's required by Clause 1, Amendment 5. But the problem there is that the judicial branch has no authority and no power to legislate, right? They have no power to create the law. They cannot alter, amend, or destroy the Constitution of the United States, because that must be done by an act of the people in accordance with the special amending procedure of Article 5. There's only one way to change the Constitution, and that is through the authentic act of the people, not through judicial fiat. And yet that's the basis of sovereign immunity, is the judicial branch. They altered, amended, or destroyed the Constitution of the United States by saying, well, it doesn't say it, but we're going to say that it does. And from that moment forward, then sovereign immunity was born and states became immune. But there's a couple problems to that. One is that if you read the Constitution, and if you go to Article 7 of the Constitution, which is right before those people sign the Constitution, what you'll find is that it says this is adopted by unanimous consent of the states. And consent is capitalized. The only word in the whole Constitution that's fully capitalized, consent, because the states gave their consent the moment that they adopted the Constitution and subjected themselves to the supremacy of the United States Constitution. There is no consent that's required. Under the Tort Claims Act, there's 4 ways in which government can waive its sovereign immunity. One is taking action in any case. If they become a party in that case, they're taking action in it. And according to the Tort Claims Act, there is no sovereign immunity. They can sue or be sued.
Wow. I am so glad that I have you on my show today. We're going to have to do more shows. But, okay, so tell everybody what you're doing, what you need from them, if you need anything, what you would like to do, and how the advocates, I'm an advocate, Spanny's an advocate, I got other advocates. What can we do to help you help us?
Yeah. So right now,
also a quick question.
Right now,
oh, hold on.
Yeah,
Go
I do
ahead,
have a
Stan.
quick question. So what do you do in example of a court where, I don't know, Judge Stephen L. Schaefer, since, he's my favorite problem child, it blackmails parents and says, you have 5 minutes to sign over your rights to your children, or I throw you in jail. And he's done that multiple times. And he froze.
extremely close together on the criminal spectrum. Okay, robbery and extortion are extremely close. Robbery is to formulate a contract through illegal means with the threat of immediate bodily harm. Extortion is to formulate a contract through illegal means with the threat of future harm. Okay, so I have certain powers as a United States citizen. I have the power to bear arms. If I go and buy a gun, I point that gun at you and I say, if you don't give me your money, I will shoot you. We are formulating a contract for your money. But the way in which we're doing it is through the use of duress. Therefore, you're not making that contract maliciously, and as a result, a crime has been committed. Right? I've committed the crime of robbery. I've stolen from you. I've formulated a contract through illegal means with the threat of immediate bodily harm. If I'm a prosecutor or I'm a judge and I say to you, if you don't sign your rights over your child, I will send you to jail. Is he not formulating a contract through illegal means through the duress that he's inflicted upon you in order to formulate a contract? And is not duress a justifiable defense for a crime, a breach of contract, or a tort? So when you use
Yeah,
duress in order to formulate a contract with the threat of future harm, i.e. throwing you into prison and taking away your life or your liberty, right? Fundamental constitutional right. Is he not formulating a contract through illegal means? And thus that contract has no validity. It's void. And it's no different than a robber using a gun but they're using prison instead of the gun, and they're taking away your life instead of your money. I mean, extortion is a crime, right? It is the collection of unlawful debt, right? And so when you use extortion, when you use duress in order to formulate that contract through an abuse of your powers, be it the judge or the prosecutor, that is a crime. It is a crime. It's a crime that's punishable as a felony with more than 10 years in prison on the federal level.
yeah, and then
But
we
when
go
you
to get the
abuse your
court
discretionary
documents.
authority,
Then we'll go and try to get the court documents, which should be in there, you know, because it's court record, and he has it all blacked out.
so remember, your testimony is reality, and it's true. So you don't have to have the court documents because the action occurred, right? Your testimony is sufficient to as evidence. When you put it into a form of an affidavit, which is considered truth of common law, you place that into an affidavit and you say that this happened to me. It happened to you. It's real. It's no different than a law enforcement officer putting it into affidavit saying, "Oh, this is what happened." Well, all he's saying is that this actually happened. You can do the same thing. So what we're doing is, you know, we were in Las Vegas a couple weeks ago, and I've tried over and over and over again to adhere to the rules that have been established by the system that they're refusing to follow. And as a result, I went into the U.S. Attorney's office there in Las Vegas, and I sat down with them and I said to them that I'm no longer going to ask criminals to stop committing crimes. I told them I'm no longer going to work within the rules and parameters of a system that it itself does not follow. And so I told them that the next time that they hear from me, I will be walking the Supreme Court of the United States with 500,000 criminal affidavits for the crimes being committed by agents of government, particularly the prosecutors and judges, just like what you said right there, right? We'll walk in with these criminal affidavits for these crimes that are punishable by death, by the way, right? And we'll let the Supreme Court decide what they want to do with it. If 500,000 is enough, then I'll go back out and I'll get 12 million. Because there's 70 million people across the United States of America today that have been convicted of crimes unlawfully in violation of the United States Constitution. That's 70 million people that we could pick up for criminal affidavits. And not only that, but when you deal with the CPS issue, right? When you deal with the CPS issue, every single time that they take a child away, I can get 4 affidavits for each one of those. Because the child had the right to be a son to the mother, also a son to the father. Then the father had the right to be a father to the child, and the mother had a right to be a mother to the child. I can get 4 criminal affidavits, 4 felonies against a prosecutor, a judge, CPS, against them for crimes that are punishable by death. So let me explain what's going on. This is a criminal affidavit, okay? When CPS comes in and they say, I want to take this child away. I want to take away this fundamental constitutional right under the authority of a state law that allows me to do that. Right? And I'm going to deprive this person of a right that's guaranteed by the Constitution of the United States, their right to have that child and have that intimate familial relationship. When they do that, that is a felony. Title 18, subsection 242. Any person who, under the color of any state statute, ordinance, custom, or regulation, deprives any person of any right secured by the Constitution, commits that crime. So whoever prepares that document and submits it to the judge just committed a factual felony, punishable by death. Because if it occurs in conjunction with a kidnapping, it is punishable by death. So when they take this to the judge, they say, Judge, sign this document taking this child. And that judge signs it without performing the correct judicial test that's required for a fundamental constitutional right. He has now established a conspiracy to deprive of rights. Title 18, subsection 241. When this judge then takes this document after he signs it, right? And once again, this is factual. This is a factual offense, right? We don't need any more than just this document saying we took it away, right? When he takes this and he hands it to law enforcement or he hands it to CPS and says, go take this child, then that law enforcement or CPS is now implicated. Whoever goes out and does that and performs that is implicated in the conspiracy to deprive of rights. This happens every single day, hundreds, if not millions of times every single day, this exact same scenario. Every single judge in the country is committing these crimes right here, right? When they take that child, that becomes kidnapping because they did not have authority to be able to take that child. Now you have a crime that is punishable by death, and you have the branches of government, you have the executive and the judicial branch that are tied up into it in a per se offense. Per se meaning that I don't have to prove that they intended to breach the obligation. Simply by virtue of the breach, all elements of the crime have been met. They did it. It's factual. It's in this document. They took the child away. So when they choose to rely upon an inferior state law to deprive you of a right secured by, enumerated in the Constitution of the United States under the authority of the Supreme Court, because the Supreme Court has already declared that you have the right to intimate association. When they do that, that is a crime. And when they commit a crime, the outcome is criminal. It's unconstitutional. There's no action or authority to be able to do it because it derives from an illegal and unconstitutional act. So,
Okay, so second part of your
what
question.
we're doing right now is I need 500,000 of these. I need a half. We've got maybe 100,000 so far, somewhere around 100,000. We'll reach the 500,000, but I need 500,000 of these, right? I need you guys to put your faith in me and the things I'm saying, because I can win this argument. I will go in there and I will win it. If I go into the Supreme Court with 500,000 of these criminal affidavits from all, I mean, we've got 12 states already that's in it. I need all 50. Once we do that, they will hear this case. They will hear it. They will let me have this debate, and I will win. I will win because the law that I'm relying upon is the United States Constitution.
Okay.
Go ahead, Spanny.
Second part. Yeah. Sorry. Was it me or you to go?
You go.
Okay. So A, you stopped by West Virginia, you'll get a whole bunch. And B, so when Schaefer throws you in jail for that right then and there, how do you get out of jail?
So this is the thing, you guys. We're not going to get the outcome that we're looking for at the lowest court.
Right.
We're not going to get it. Nothing is going to change until we get to the highest court. I need you guys to put your faith in what I'm doing, what I'm saying. Stop playing with the lower court. The lower court is not going to correct their actions. We will not get criminals to stop committing crimes.
Right.
The only thing that we can do is go to the highest court in the land and make them hear this case, which we can. We absolutely, I can make that happen. But I need the backing. I need the numbers, right? I need the numbers. But once we do that, then the highest court in the land, they're going to side with this. And the reason why is because if they don't, they just voted themselves out of a job. They will preserve their institution. They will preserve their job. We just have to get it into their hands. They will stand and do everything in their power to prevent from having to do this because it's such a big deal and because they're going to have to admit all these wrongs have been done. But I don't give a shit, right? We're going to put it in their hands. We have one obstruction left. That is the clerk of the court. Once we overcome that obstruction, it will be in the hands of those 9 justices, and they will side with us because they will side consistent with what the law states. Consistent. Now, there's one other thing that I'm doing here, right? Is if you were to go out to my Facebook page, down in it, and I should probably pin it to the top, but I prepared 2 letters, one for United States senators and one for United States congressmen. And what I'm trying to do here is, Sun Tzu, he wrote in the book The Art of War, he said that there's 4 ways that victory can be known, right? But the very first step in securing victory is you must break up the alliances, right? You must disrupt the alliances. So we have an alliance between the 3 branches of government right now today. We need to get one of the branches of government to create oversight to correct the illegal actions of another branch of government. So right now today, what's happening is the executive branch is the one that's responsible for what's going on. They're the enforcement branch and they're enforcing the laws improperly. The judicial branch, they're just rubber stamping this shit, right? But that's what they're doing. So they're not making sure that the proper documents are in place or the proper procedures are done by the executive branch, even though that's their responsibility to provide that oversight. So the judicial branch is implicated in this conspiracy, but they're not ultimately responsible for it. Who was responsible was the executive branch. So what we're trying to do is the legislative branch, although they have their own responsibility in plenty of things that we'll be dealing with the court, but the legislative branch, we can use them as a mechanism because if they want to be reelected in this national, election cycle right now, they're going to have to choose a side here, because if they don't, they're not going to be elected for a goddamn thing, right? So when we take those letters and you send them into your representatives, being the 2 United States senators and your United States congressmen, and you demand an action item request to investigate these acts of corruption that's occurring, these deprivation of rights in the color of law, which I just spelled out. I mean, you know, when you go out and you read it, it's clear. They committed a crime, punishable by death, and the judge did it as well, right? There's no denying this crime has occurred. So when we submit it to the representatives in Washington, D.C., the senators and the congressmen, we're giving them an opportunity to say, do I want to be a part of this or not? Because what they need to understand is that I may not have a whole lot of momentum right now, but we're about to go on to a national news network. They're about to run a story on this, a complete interview with me, and we're going to put this information out there public. And when it goes public, if they haven't chosen a side, they will be part of the criminal conspiracy. Because any person who, having knowledge of any of the wrongs conspired to be done and mentioned in that section, and who have the power to prevent or aid in the prevention of the commission of the same, neglects or refuses to do so, may be joined as defendants in the action. If they want to make sure that they're not implicated in this once it comes forward, the only thing they can do under the conspiracy laws is, 1, notify authorities of the crime, or 2, notify their co-conspirators of their intentions to no longer participate in the criminal conspiracy. That's the only way that you can negate your culpability in a criminal conspiracy. So I need them to understand that they have a choice, and they don't have a whole lot of time to make their choice. But their choice is, are you going to comply with the Constitution or not? Because once I get this out on the national stage, which could be next week or the week after, and it's with a station that doesn't give a shit about the Attorney General, who's not going to be taking it down. So this is going to be out there in another week or two. And if they haven't done something about it, despite the fact that we've notified them of action item requests, told them about it, they had the power to prevent or aid in the prevention commission saying they become culpable in it, and they can then be joined as defendants in the action. So we want to make the legislative branch decide of their own thinking, their own contemplation, to do the right thing, conduct hearings, get me to Washington, D.C., so that I can have a remonstrance on this, and so that we can address this issue. If they don't do that very quickly in the next week or two, it'll be too late. Because once this goes public, we've already notified, I personally have notified every single one of them. Every single senator, I've notified every single one. They have it. I've got the receipt of their confirmation that they've received the document. You know, it's up to them. They want to be ignorant to it. That's cool. Ignorance.
Wait, you got to Alaska?
Huh?
Said, wait,
yes,
you got to Alaska?
Oh,
Awesome.
no, I sent it to them in Washington, D.C.
Oh,
So
okay.
every single United States senator has received a copy of the information, and I've received confirmation that they've received it by a response email from their office. So they have the information. So now they have the knowledge of the wrongs conspired to be done, and they have the power to prevent or aid in the prevention of the commission of the same. And if they neglect or refuse to do so, they can be joined as defendants in the action. And if that's the case, when this comes public, I get to tell every single one in that public interview that every single United States senator has been made aware of this, and they chose to do nothing about it. How do you think that's going to affect them in their political campaigns?
Well, it's not going to go over very well. So if you can, okay, so let me make this clear. You even want CPS cases?
Absolutely. Absolutely.
Child support cases, because they're railroading people in court into these contracts that they don't even consent to.
Child support.
All of it. You see, with the child support, it's the same thing. So child support, when you deal with a racketeering enterprise, if you were to read the racketeering law, I think it's 1601, it says racketeering is the collection of unlawful debt. Unlawful debt. Well, the debt is being created by a branch of government that's not legally constituted with the authority to be able to create that debt. The reason why is because in a courtroom, the legislative branch is represented by the jury. The jury is the one that determines whether or not there's a debt. Well, according to Article 1, the only branch of government that can create a debt against the people is the legislative branch. So absent a jury determining whether or not there's a debt that exists, it is being created by a branch of government that is not legally constituted with the authority to create the debt against the people, being the executive branch, the prosecutor, or the judge, the judicial branch. That's what makes it fraudulent. That's what makes it invalid, because those branches of government cannot create a debt against the people. It must be done by the legislative branch, and the legislative branch is represented in the courtroom by the jury. Absent a jury, there is no debt that's lawfully created. And as a result, the collection of unlawful debt, in other words, the racketeering enterprise, right there, they're collecting unlawful debt.
I
We have,
was
we have,
gonna represent my husband in a child support case because they retaliated against him because I took their ass to court and I made them give me my money back. There wasn't no ifs, ands, or buts. I even told the judge, I don't care if you dismiss it. That's what I want you to do. Because I'll see everybody in federal court. And then everything changed then, right? Oh, no, we're not done. So after they had to give me my money back, they hit him with a failure to pay court-ordered child support. Because I'm like, send them $5. They can't touch you if you do $5 a month. It's like any debt collector. They can't sue you.
well, hang on. If you agree to pay even 1 cent, then you've agreed to the validity of the debt. You can't agree to anything.
Anything. You know what they told him?
Nothing.
You need to
Yeah.
pay or we're going to jail.
Yeah. So intimidation, the formula of intimidation, which is what our case is bringing forward, right? Formula of intimidation. All intimidation follows this formula, and it goes like this. If you don't do X, I will do to you Y, whereby X is my envisioned outcome and Y is the result of my powers and cause. So in the case of the robber, right? If you don't give me your money, I will shoot you. My envisioned outcome is I want your money. Result my powers cause, I will shoot you. That's robbery. Formula of intimidation. If I'm a prosecutor, it follows the same formula. If you don't plead guilty, I will send you to prison for 20 years. Or if you don't pay your child support, I will throw you in jail for 6 months. It is still my envisioned outcome is I want your money or I want your life. My envisioned or the result of my powers and cause is I will send you to prison. Right? It is still following the same formula of intimidation. It is still an act of racketeering and the collection of unlawful debt in violation of 1601.
I even told these people, you cannot enforce an administrative order. There's no judge's signature on this administrative order. There's no clerk seal. There's no court seal. This is the court order. Look up the United States versus Sage. And the judge rolled his eyes.
Yeah. If you consider the fact that the administrative court versus the criminal court, that is a civil matter versus a criminal matter. You cannot have debt be the basis of a criminal liability because that's a civil matter, right? Law enforcement can't enforce civil law. So, they're mixing and matching civil matters with criminal matters. They're using the criminal statute in order to advance their civil codes or their civil desires, and you can't do that. You can't use a criminal statute to create the pressure to make a person do what you want them to do without committing extortion.
It says failure to obey. I said they better be glad that she said, because I typed up a paper, I filed it. She knew I filed it because she said, Mr. Wise, or you or somebody's filing all this paperwork. I said, because the Fifth Amendment does not say lawyer. I even went back and read it. It says counsel, right? You can elect your own counsel. He elected me. She said, absolutely not. Miss Wise is not a party to this case. Miss Wise is not a lawyer. She better be glad that she shut me up because she was about to get it. What she said, I got it handwritten.
So remember, the 10th Amendment. The 10th Amendment says that those powers not delegated to the United States and not prohibited by the Constitution are reserved by the people and the states respectively.
This is the same judge that tells you the Constitution does not apply in her courtroom.
And that's the reason why, Norton versus Shelby County said that any unconstitutional act or law, it creates no powers, it creates no authority, it has no action. It is wholly inoperable as though it never existed. No court is bound to adhere or enforce it. No person is bound to follow it. So if we understand today the true reality of the fact that the state courts do not have jurisdiction because they're taking action in their own case in which they become a party in that cause, then don't respond to them anymore. Why are we even talking to them? Right?
Because if you don't bring your behind the court after the quote unquote sheriff serves you, which is an unconstitutional paperwork to begin with, and the sheriff's department is supposed to be the constitutional watchers versus code enforcers like the police. But anyway, that's a whole other episode, right? And the sheriff comes and arrests you for rapist because you didn't show up in court because the judge made you or sent you an invitation to
Yeah.
come and you did not.
Yeah. So I know that we're getting really short on time here, but I want to say a couple things. One is that I'm out here and I'm doing this because this is the right thing to do. I used to be an engineer. I owned a great big engineering firm. I was multimillionaire. But God had me change, and he brought me back to my original love, which was substantive law. I have a master's in it, went to George Washington University. You know, I'm fully qualified to do exactly what it is that I'm doing right now. And I love it now. I mean, I've never been more proud of myself than I am right now and the things I'm doing, because this is absolutely what I was meant to do. I was meant to fight for you guys, right? I was on the wrong side for a long time, and I'm glad that I've been brought back. But the thing is that I need the help from you guys, right? I mean, you know, you guys want to pose your battles within your courts because you want to get action, you want to get justice. We will not get justice where you're looking to do it. You're not going to get this fixed from the bottom up. We must do this from the top down. That's why the We Shall Be Free tour, it says fighting crime from the top down. I'm going to the court that is ultimately responsible for the injustices that you and your family have experienced, right? I'm going to that court, and I'm there, and I have the argument, and we have one obstruction to get over, and that obstruction we can get over with 500,000 criminal affidavits, right? If you guys give me these, and if we can get these within the next 20 to 30 days, then I'll walk in that court, they will hear me, and we will get this resolved, and we'll get it resolved very, very quickly, right? I know that people have lost hope and faith, but if you have faith in the supreme law of the land, right? The supreme law, and you read the words that it says, and you understand the concept that any law that is not the Constitution is unconstitutional simply by virtue of the fact that it is not the Constitution, then you can understand that the only law that we have to argue is the Constitution of the United States. Don't come down off of the highest form of law to argue down the weeds with case law. Don't come down in the weeds to argue with state statutes. None of that matters. It is all unconstitutional simply by virtue of the fact that it is not the Constitution. You rely upon it and it alone, and in doing so, you will secure your freedom, because that is the document that guarantees your freedom. That's the reason why it's not used in those state courts, because those state courts are in the business of removing freedom. Therefore, they rely upon laws that remove freedom. You want to restore freedom, rely upon the document that guarantees your freedom. And that's the only thing. Once you do that, then you can cut through the bullshit, you can cut through the lies, and you can know that we will win. We will prevail. And they will side with this because they have no choice. If they don't, they just voted themselves out of a job, and they just destroyed the United States of America.
Okay, so this is what we need to do. Spanny, I don't know if you already have them. I want copy. Just send me one of each, because I will start handing them out in my own town. I advocate a lot here against CPS, and I've been winning. So we can do that. I'm telling you, we got to get these papers out, people. Get them filled out. If you all want change, look, I told you before.
She froze. Give her a second. Anyways, they're on Tanawah's Facebook page.
So there's one other thing, if we could. So the work that I do because God's compelling me to do it. I'm going to be successful in it because it's the right thing to do, and because I love my country, I love my fellow countrymen. I want to see this happen. We got to preserve the familial unit, and that is the number one thing that's destroying our country faster than anything else, is the destruction of the familial unit. But we do have tangible costs. You know, we're in Florida right now, and it's very difficult for us to do this work, particularly from the fuel perspective, because you know we don't get paid, but I don't want to be paid. So one thing that I like to make sure everybody understands is that I will work for everyone, but I will not work for anyone, right? That my power resides in my ability to speak on behalf of everyone and speak for them, right? So I'm not for sale. I'm not a lobbyist. I'm not gonna come and fight one individual battle when I can fight everyone's battle together cumulatively, and that's where we're at. But we do have some actual costs. If anybody's willing to donate and provide, every single dollar is essential to making sure that we can reach out to the people that we need to reach out to. Again, we've got some big news interviews that are coming up a couple radio interviews, as well as that one national interview. And so we got to get to those locations as well. If anybody's willing to support, we have Cash App, we have Venmo, we have Chime, we have PayPal. They're all exactly the same. We shall be free. We shall be free. All for them. And we would welcome any blessings that come our way. Just know that this isn't easy. It's not an easy task to do. We're up against the biggest narcissist that's known to mankind, and it's known as justice. And we're going to overcome this narcissist, but we have to do it in a very, very slow and very very intent manner.
Practical.
Yeah, very intentional. And so, when people want to see speed, speed is what they rely upon. We can't have speed. We got to be very methodical in this. We've got to be very intentional in our acts. We've got to do this in a very non-destructive manner. And the best way to do that is by making them come to terms with the understanding that they are criminals, and they will remain criminals as long as they breach the law, because a criminal is simply one that transgressed the law. If you choose to violate the law, and I bring it to your attention that you're violating the law, and you choose to continue to do so, well, now you have no choice but to accept the title of criminals. And I don't think that any one of the judges or prosecutors want to be known as criminals. So we've got to get them to understand in their own contemplation that what they're doing is criminal, and return to the established rule of law and get behind this. And we use the law itself against them in the same way that they've used it against us. So that's where we're at.
I'm going to help you in any way I can. I'm all on board. I don't know what else to say. I definitely want to stay in touch with you guys. And I know that'll happen.
So what time next week?
It doesn't matter.
Anytime.
But let's set that up after the show, because I don't want that. You know what I'm saying? Let's just once we go off live, then we'll talk about it. So for now, we're going to go ahead and sign off.
Well,
yep.
So thank you all so much for letting me serve you and your family. Amber and I, we're here for you guys. We're doing this for you guys. And I'm very proud to be able to serve you and your family. So thank you guys so much for letting me do this. Okay.
All right. End the show, but stay on.